Hello everyone, I'm Brian Beamish, Ontario's Information and Privacy Commissioner. Welcome to the second installment of our online webinar series. The goal of this series is to engage stakeholders on the important issues they face under Ontario's access and privacy laws. Today, our focus is understanding exemptions and other issues that arise in processing access to information requests under the Freedom of Information and Protection of Privacy Act and its municipal counterpart, MFIPPA. Over the next hour, we'll provide an overview discussing principles behind certain exemptions, how they are applied, and how they have been interpreted by our office. As well, we'll talk about some of the issues that come up from time to time in dealing with access requests. In future, we may devote additional seminars to specific exemptions. Our main presenter for today's webinar is Assistant Commissioner David Goodis. Following David's presentation, which has been pre-recorded, Assistant Commissioner Sherry Liang, Manager of Adjudication Frank DeVries, and I will be pleased to take your questions. Afterwards, the presentation, this webinar, and additional materials will be made available on our website. Please feel free to submit questions during the presentation using the on-screen form. Your questions will be read anonymously and others will not be able to see them. Please keep in mind that we have around 600 people participating in the webinar today, so you may want to get your questions in early. And Sherry, Frank, and I will do our best to get to as many as we can. With that, let's begin the presentation.
Welcome to the IPC's webinar on understanding exemption. We will be discussing exemptions in the Freedom of Information and Protection of Privacy Act and the Municipal Freedom of Information and Protection of Privacy Act and how they are applied. We will look at our general approach, some interpretations, and highlight some key decisions. The basic principle of Ontario's access and privacy laws is that everyone has a right of access to government-held information. FIPPA covers all ministries of the Ontario government and any organization designated as an institution under the law. MFIPPA covers all municipal bodies, including municipalities, local boards, and commissions. This includes, for example, police services and school boards. Any record can be requested. A record is defined broadly as any record of information, however recorded, whether in printed form, on film, by electronic means, or otherwise. The law tells us that exemptions from the right of access should be viewed as limited and specific. There is a right of access to all records in the custody or control of an institution unless the contents are covered by an exemption, the request is frivolous or vexatious, the record is specifically excluded, or another act overrides FIPPA or MFIPPA. Under the acts, government institutions can refuse to disclose records containing certain types of information. Exemptions fall into two separate categories: mandatory and discretionary. Mandatory exemptions require the head of an institution to withhold the record. Mandatory exemptions begin with the words, "A head shall refuse to disclose." These include relations with other governments, which is mandatory under MFIPPA only, cabinet records under FIPPA only, third-party information, and someone else's personal information where disclosure would be an unjustified invasion of their privacy. Discretionary exemptions allow the head to disclose a record despite the existence of the exemption. Discretionary exemptions are introduced by the words, "A head may refuse to disclose." These include a record of closed meetings under MFIPPA only, advice or recommendations, law enforcement, the institution's economic interests, solicitor-client privilege, danger to safety or health, information soon to be published, and the requester's own personal information, even where mixed with another person's information. It's important to remember that just because a discretionary exemption applies, that does not necessarily mean that the record can't be disclosed. The institution must take the added step of deciding if the information should be disclosed despite the fact that it qualifies for exemption. In other words, an institution must properly exercise discretion. The exercise of discretion is a key component of the access process. In exercising discretion, it's important to consider all of the facts of a particular case and to weigh them fairly. As an example, take a requester who is asking for information in a police occurrence report in which she was involved. The report contains her information mixed with the information of other people, and the police believe it might be an invasion of the other people's privacy to give the requester that information. Because she is asking for her own information, the police have the discretion to either withhold or disclose the information of those other people. In exercising this discretion, the police should look at why she needs the information, the type of information, and all the circumstances to decide whether her right to the information outweighs any privacy rights of the other people. One question that comes up often in applying the acts is, well, what is personal information? Privacy rights under the acts only apply to personal information. An institution can only claim that disclosure of a record would be an invasion of privacy if the information in the record is personal. Personal information means recorded information about an identifiable individual. As I've already mentioned, recorded information can be in any format, such as paper records, electronic records, digital photographs, videos, or maps. Identifiable means that even if a person's name is not in the record, it might still be their personal information if they can be identified. For instance, if a requester asks for a witness statement and knows who the witness is, then even an unsigned statement will be that witness's personal information. The Acts define personal information and list examples of personal information such as address, sex, age, education, or medical history. These are just examples. There are many other kinds of information that may also qualify as personal information. We are often asked about the differences between personal information, property information, and business or professional information. As a general rule, information about an individual in a business, professional, or official capacity is not considered to be personal information, even if it identifies them. However, this information may still be treated as personal information if it reveals something of a personal nature about the individual. For example, a resume will include a mixture of personal and business information. In addition to a current job title and company name, it might include the individual's education history, personal activities, and other personal information. Another example might be the details of a harassment complaint against an employee of an institution, which likely will contain a mixture of personal and professional information. Even though the events happened in the workplace, the details in the record may reveal something personal about the employee. The context in which the information appears is important. As a general rule, information about a property is not considered to be personal information, even if the owner or tenant are able to be identified. However, this information may still be treated as personal information if it reveals something of a personal nature about an individual. For example, information relating to water well samples taken from properties or the addresses of properties which were tested for mold is not the personal information of identifiable individuals. Some types of records are excluded from the Acts. If a record falls under an exclusion, the Acts do not prevent disclosure, but there is no statutory right of access. The government may choose to disclose it outside of the Acts. Examples of excluded records are those relating to ongoing prosecutions, labor relations or employment-related matters, academic research, or hospital privileges. Under the Acts, every person has a right of access to a record or a part of a record in the custody or under the control of an institution, unless specific exemptions apply. So how do we know if a record is in the custody or control of an institution? It goes beyond the physical location of a record and involves factors such as the purpose of the record, who created it, and whether or not it relates to the institution's mandate or functions. A record doesn't need to be both in the custody and under the control of an institution. It can be one or the other. When a record isn't in the custody of the institution, if, for example, it's sent from a personal email account at a private residence, then the question is whether it's under the institution's control. In deciding this, you need to consider, do the contents of the record relate to the institution's business? And could the institution reasonably expect to obtain a copy of the record on request? Here's an example. Patricia asks her municipality for all records pertaining to a special task force of councillors, trustees, and city staff exploring a proposed public education program. Information that might be in the city's custody or control could include minutes from meetings, proposals submitted to the task force, emails between task force members and city staff, or plans and recommendations produced by the group. These records were created for a city project. They are related to city business and are expected to be in the city's possession. Information which might not be in the city's custody or control include email records between councillors and their constituents regarding their concerns. These are related to the councillor's role as an individual representative, and the records are political rather than city records. Another example would be information gathered by an individual councillor for her own research on the issue, kept with her own papers, and never shared with the other members of the task force. In these cases, the institution likely does not have physical possession of the records, and it doesn't have the authority to regulate those records. Here are some significant decisions on custody and control. In a series of municipal orders, a number of requests were made to different school boards seeking access to student transportation procurement records from school board consortiums financed by the Ministry of Education. The boards denied access, in some cases stating that the consortiums were independent entities. Therefore, the consortium, not the board, has custody and control of the responsive records. The IPC found that the consortiums are actually part of the boards. But even if the consortiums are not part of the boards, then the boards still had control of the responsive records. The records relate to the board's business, and the boards could ask for the records and expect to receive them. In contrast, in a court decision which overturned one of our orders, the court said that emails by an employee of an institution which related to that employee's volunteer activities, unconnected to the business of the institution, were not in the custody or control of the institution, even though they were sent from a business account. Institutions subject to FIPPA and MFIPPA often acquire information about companies in the private sector. Some of this information may be a valuable asset to the company, and its disclosure would impair the company's ability to compete effectively. Under Ontario's access laws, third-party information shall not be disclosed if it reveals a trade secret or scientific, technical, commercial, financial, or labor relations information is supplied in confidence and where the disclosure could lead to certain types of harms. Here is an example of how this exemption might apply. Take a request to a ministry for any records related to the cancellation of a large infrastructure project. The response might include a variety of emails, briefing documents, bids from contractors, etc. Information which might be exempt from disclosure includes a company's secret process, design, or formula that is included in a bid for the project, a company's proprietary technical information, such as architectural or circuitry designs, or a company's operational or development costs and cost analyses. This information could be considered trade secrets, technical, or financial information within the meaning of the third-party information exemption. If it was supplied by the company under an understanding that it would be kept confidential and the company would be significantly prejudiced in the marketplace if this information was disclosed, then the institution would be justified in withholding it. Here are some examples of how the third-party exemption has been applied. In Order PO 3311, Ontario Power Generation denied a request for records related to engineering, procurement, and construction agreements with two companies for the refurbishment of nuclear reactors. Our office ordered large portions of the agreements to be disclosed, but upheld OPG's decision to withhold specific technical information and information where disclosure could prejudice the affected party's competitive position. In Order MO 3179, a requester sought access to information from the City of Toronto about a request for proposals for graffiti removal services. The records at issue form part of the third party's winning submission in response to the RFP. Parts of the records were found to be exempt, such as the identities of the third party's clients, detailed information about the work performed for other clients, and a portion of the company's training manual. But the city was ordered to disclose additional parts of the requested records. Note that the IPC will normally order disclosure of the financial details of contracts, including unit pricing. On to frivolous and vexatious requests. Sometimes an institution may refuse access because it believes that the request is frivolous or vexatious. What makes a request frivolous or vexatious? A request can be found to be frivolous or vexatious if it's part of a pattern of conduct that amounts to an abuse of the right of access, is part of a pattern of conduct that would interfere with the operations of the institution, is made in bad faith, or is made for a purpose other than to obtain access. Here are the types of considerations our office takes into account in deciding whether an institution was right to treat a request as frivolous or vexatious. There was an excessive number of requests by the same person. The requests are excessively broad or identical to previous requests. The purpose of the requests is aimed at creating a nuisance, to harass the government or burden the system, and the behavior of the requester. All circumstances must be considered when deciding whether a request is frivolous or vexatious. Decisions by this office confirming that a request is frivolous or vexatious are not common. Here is an example of how to determine whether requests are frivolous or vexatious. A requester has filed 10 requests in 3 months with an institution for records about a controversial project which has garnered significant public attention. Although this may be considered a large number of requests relating to one project, there may be good reasons for making these requests. The requester might be looking for specific details about the project. The institution must consider if the requests are repetitious or overly broad, and whether each request asks for unique information. Institutions must remember that the Act provides individuals with their right of access, and the institution must provide evidence that there are reasonable grounds to find that a request is frivolous or vexatious. If requests are repetitious or too broad, it is advisable to contact a requester to discuss their needs with them, to try to find a compromise before making a finding that the request is frivolous or vexatious. Here are some examples. In Order PO 3539, requests made to a ministry were found to be frivolous and vexatious because these requests and the actions of the requester established an abusive pattern of conduct. The requester had made 44 requests in under a year, and based on the number, nature, and content of the requests, his actions were found to be frivolous and vexatious. We limited the requester's right of access to one active appeal or request at a time. In Order MO3278, a region received a request for records about the housing cooperative where the requester resides. The region responded by declining to process the request on the basis that it was frivolous and vexatious. We found that there was insufficient evidence to establish that the request was made in bad faith and ordered the region to issue a new decision. These orders and others are available for review at ipc.on.ca. This concludes the presentation. Our office is committed to protecting the public's right of access to information. We are available to answer your questions about Ontario's access to information laws. Thank you.
Welcome back, everyone. We've received some excellent questions over the course of David's presentation. I'm going to start with a topic that David did touch on, and that is frivolous and vexatious requests. It's something that we're asked about quite often. One question relates to solicitors putting in what's called a fishing expedition type FOI request, I guess to determine whether there is material that might assist a lawsuit, for example. Sherry, would that type of a fishing question be in and of itself frivolous or vexatious?
Not by itself. Just because a request is broad doesn't mean that is a frivolous and vexatious request. As was discussed in the presentation, we would be looking at whether there's a pattern of conduct, whether there's bad faith, whether it's clear that the purpose is other than to get access. More needs to be shown before a request like that would be considered to be frivolous and vexatious.
Another question relating to frivolous and vexatious, which is really good. What if the issue that's the subject matter of the request is something that has been addressed outside of the FOI process? For example, it relates to an issue that the Ombudsman has dealt with or a professional body. In that type of situation, would we consider that frivolous or vexatious? Frank, do you have a views
Sure.
on that?
I guess it's a good question. I guess the issue would be whether or not the requester, in the context of making the request, is doing so as a frivolous and vexatious requester and would meet the requirements of the Act, which are set out in the Act and the regulations. The fact that there's another process that's ongoing and that might overlap somewhat with the Freedom of Information process in and of itself is not a reason that a request would be frivolous and vexatious. However, I guess if there's a lot of overlap and there's evidence of that, that might be something that an adjudicator would consider in reviewing the head's decision.
I guess a scenario like that may raise questions about the purpose and whether the purpose is just to harass the institution if there are multiple proceedings about the same issue. And in any situation where an institution is concerned that it's being subject to frivolous requests, it should really be documenting its interactions with a requester, recording the number of requests, the burden on its staff, the apparent purposes, any evidence that it has, because at the end of the day, when it comes in front of us, and if there's an appeal over a decision that a requester is frivolous and vexatious, the institution would have to show us that evidence and really make the case for why the criteria are met, because it is a pretty serious thing to find that requesters request is frivolous and vexatious, typically if we make that finding, that person may be limited to a certain number of requests in a year or appeals in a year. So it does have a dramatic impact. So we do want to make sure that the evidence is there before we make that finding.
I think that's a really good point to finish on in dealing with frivolous and vexatious. And from my experience, the times where we have found a requester to meet that criteria, the institution's done a very good job of recording the history of interactions and hasn't simply at one point in time decided they wanted to make that decision, the person was frivolous and vexatious.
Yeah.
It really comes down to the kind of evidence that can be submitted.
Yeah.
Let's move on to a unrelated question, and that is dealing with Section 15, which relates to material received from other governments or relations with other governments. And the question is, can information that is shared through a federal, provincial, territorial working group meet the criteria in Section 15? Frank, can I ask you to answer that?
Sure. Section 15 doesn't come up that often in our decisions, but we've certainly reviewed federal, provincial working groups and confirmed that in certain circumstances, that kind of information that's shared between the federal and the provincial levels of government can fit within the criteria in Section 15. Section 15 is quite specific. It requires that there be prejudice shown if there was to be disclosure, or that disclosure would reveal information received in confidence. So that kind of evidence has to be provided, but certainly in the context of federal, provincial working groups that might apply, and we've made those findings in the past.
Great. A section that we deal with a lot is Section 17 of the Provincial Act, Section 10 of the Municipal Act, dealing with third-party information. We have a couple of questions on that. The first one is, if a third party indicates that information requested through the FOI process is subject to that Section 17 exemption, does an institution simply take their word for it, or does the institution ask the third party to demonstrate or prove that they meet the criteria set out in the section?
Well, I think there has to be some evidence, and so it's up to the third party to bring forward the information that justifies applying that section, because after all, if the decision is to deny access to a record just based on a mere statement, the requester has the right to appeal that decision to our office. And if there is really a lack of evidence, then that's going to make itself apparent pretty quickly. So yes, institutions should be asking the third party for information about why the exemption applies.
In a scenario that we see quite often is that the institution may, after consulting with the third party, make the decision to disclose the record and then put the onus on the third party to file an appeal. Right. As well, on the third-party exemption, quite often the third party, when being consulted, will ask, who is the requester? In other words, who put the FOI request in to get access to information that relates to me? And what's the proper approach on that? Should an institution be revealing the identity of the requester to the third party?
That's a good question, and it does come up quite often. I think historically our orders have said that the identity of a requester in almost all circumstances is confidential and shouldn't be shared outside of the people processing the request. More recently, however, we've had to review whether information that's requested in the context of a business request, and the presentation talked about the difference between personal information and professional information. And if information is requested in a professional context, that might mean that the information is not personal and would not reveal something personal about an individual. This has come up a number of times in some recent orders, and so I'd encourage you to look at our website, which really has a really good search tool to search for orders that relate to those kind of issues. But I guess the default would be The identity of the requester generally is not relevant to whether or not the information should be disclosed. And even though a party may be curious as to who the requester is, it's not relevant to the question of whether the exemption applies or not.
I think just to add to that, Frank, you don't need to reveal your purpose in making a request for documents, and your identity shouldn't matter unless, of course, you're asking for your own records, and then that does drive the request. But your identity really shouldn't matter as to whether or not you get access. So if there's any possibility of the fact that you disclose the identity of the requester and that may taint the process in some way and alter your decision, then I think you need to be very careful about whether or not that's relevant to processing the request.
We have a question that combines both of the first two topics, Friv and Vex, and Section 17. Would the behavior of an unsuccessful vendor who continues to request access to the successful bids that they've lost be considered Friv and Vex, and taking into consideration that the vendor may have taken advantage of the debriefing process that's already in place? My reaction to that is no, that simply asking for access to successful bids would not in and of itself be frivolous and vexatious. That strikes me as a type of information that an individual has a right to, regardless of whether they're an unsuccessful bidder or not.
I agree with that, Brian. As we've said a couple of times, there are specific things that we look to in deciding whether or not a request is frivolous and vexatious. And the threshold is pretty high because the Act is about access. The Acts are about access, and we all have a right to access. So before we cut someone off from that right, we want to look at, as we've talked about, whether the purpose is other than access, whether there is a pattern of abusive conduct and that sort of thing, or excessive requests in a certain period of time. So we need that evidence, and I agree with Brian on that.
It's probably a good opportunity to put a plug in for proactive disclosure, because presumably if an institution is proactively disclosing successful contracts, that negates the need for people to put in a Freedom of Information request to get it. And I know we have lots of guidance on our website about open procurement and open contracting. The really interesting question here relating to security cameras. And the scenario here is that a theft has occurred at a library, and the victim of the theft would like access to the videotapes, the library's security camera tapes. And of course, these tapes will capture many individuals as they move through the library. Would the victim of the theft be able to get access to those recordings through the Freedom of Information Act? Frank, do you want to take a...
And that's an interesting question, and it's coming up more often, actually. So what it is it's a request by somebody for their own personal information, presuming that their face is on the video at some point. But it's also a request for information, recorded information about other identifiable individuals, likely. Furthermore, it's a request for a videotape record, which is clearly defined as a record under our Act. The question then becomes, is this person entitled to their own information as well as other people's personal information? And the general answer, as was identified in the presentation, is no. There's a balance to be drawn between getting access to your own information and that of other individuals. In the context of security cameras, a number of orders recently have decided that blurring, facial blurring or blurring of identifiers might be an appropriate way to allow somebody access to certain information, but not the personal information of other individuals. So that's an option. The question about whether a victim can get information about perhaps a perpetrator or somebody who committed the crime is one that also comes up quite often. generally, that information is also the personal information of the possible person who committed the crime, and so there's a balancing that takes place.
Maybe I could just jump in and say that we have had cases where we have ordered a disclosure of an individual who the requester may want to take action against over some sort of an incident or altercation. And in a couple of particular situations, people were bitten by dogs, and they don't know the names of the owners, and they may want to get some restitution for their injuries. And they've made requests for the names of the owners of the dogs. And when the record at issue, whether it be a police occurrence report or some record at a city's Board of Health or what have you, or the city's health unit, when the record includes the information of both a requester and other people involved, a requester has a greater right of access than if it just contained the information of other people. So when I say the requester has a greater right of access, what I'm saying is that the fact alone that other people's personal information may be in the record is not a trump, is not a veto against being able to get that information. The institution would have to balance the rights of the victim to that information against the rights of other people whose privacy may be at issue in the release of that information. So it's a discretionary decision. And we have had cases where the names of dog owners have been released to the requesters.
So there are situations in this case where a victim may, in fact, be able to get access to information about the alleged perpetrator.
If I can just add one thing, in these sorts of circumstances, the balancing that Sherry referred to is actually some of the criteria to look at is set out in the Act. There are presumptions that apply to personal information, and there are factors that have to be considered. And in the situations where we have ordered disclosure, usually one of the factors is there a legal right that is being contemplated? Curiosity and personal interest in information is not necessarily an overriding factor.
On the issue of cameras and video footage, we had a question from an individual who says that they are a property owner landlord and have installed cameras in a number of their buildings. And there are a couple of questions here. One is, what are the requirements in terms of safeguarding that information? And secondly, who can have access to it? For example, can a tenant request access, or could the police request access to it? It strikes me that part of that answer depends on whether the property owner landlord is a government institution or if it's a private individual. If it's a government institution, then it would be subject to either FIPPA or MFIPPA, and there would be rules around requirement that it be kept secure and rules around who they can provide disclosure to. If it's a private organization, then presumably it's subject to the federal private sector privacy law, FIPPA. Would that be your take, Sherry?
Yes, I would just add that we have recently issued a guidance on the use of video surveillance, and it's aimed at institutions that are covered by FIPPA and MFIPPA, and so covered by the privacy rules in Ontario. And I guess I'll just hold up an example of our guidances. This is not the one about video surveillance, but they look like that, and they're also available on our website. And as Brian says, the answer to that particular question may depend on whether it's an institution that's subject to the privacy rules in FIPPA and MFIPPA or a private sector landlord. But even private sector landlords may benefit from the guidance that we put in our material.
And in terms of safeguards, I know our material talks about keeping the video feed secure, providing notice on the building that there are video cameras, limiting the retention schedule so that you're not keeping information around for a long time, ensuring that access to the video feed is limited to a need-to-know basis. So there are definitely rules that the questioner will find in our material setting out what kind of security measures should be put in place. As to access by the police, I know that if this is a public sector organization, the acts do provide police a fair amount of leeway in terms of accessing information if it's a legitimate law enforcement investigation that they're conducting. Another question asked where an institution can go or who they can contact if they are seeking guidance about an FOI request. For example, are there policy advisors around who can help them? I know that we do provide that type of assistance for institutions that have questions on the Act.
We have a general info IPC website as well as phone line for general questions. One of the provincial ministries that is responsible for FOI also provides guidance as the Ministry of Government and Consumer Services. And they have people that often do provide advice, and they've issued guidance documents as well. So they might be a good source for that kind of advice.
Lastly, can I just put in another plug for our website and the new search tool engines we have for our orders? Sometimes just plugging in a couple of key phrases that might occur in previous orders will assist greatly in giving some guidance as to how our office has made decisions on particular issues in the past.
And one final point, Sherry mentioned some of the guidance that's available through the Ontario government. I know that they are also starting to look at reaching out to municipal organizations, and in fact in 2 weeks they're holding a conference here in Toronto designed specifically for municipal institutions to provide guidance on access and privacy. We have a question here about salaries. Are there cases, or do we have cases that demonstrate the level of disclosure of details of municipal employees' salaries and employment contracts to members of council or to the public if they do not qualify for the Sunshine List? I think we all know that the Sunshine List, there's a requirement to annually proactively publish this individuals who are making $100,000 or more. So here, I guess we're talking about individuals making less than that. I think the Act speaks to this in some ways, saying that salary ranges are not considered personal information as well as classifications. To me, that would indicate that if it's under $100,000, the specific salary may not be available to the public.
I think that's right. The specific exact salary might not be available, but the Section 14.4 of the Municipal Freedom of Information Act does confirm that benefits as well as salary ranges are not, there's no presumed unjustified invasion of privacy if that's the information that's at issue.
And on the issue of employment contracts, I know that we do have some orders that in general have ordered those disclosed. I recall specifically an order dealing with university presidents' employment contracts, and I believe in that case we ordered the contracts disclosed, salary, benefits, and the like. So I think our general view is that employment contracts should be available.
Absolutely. That's the way we've made a number of decisions. Occasionally, an employment contract might include some personal information, for instance, how many sick days were taken over a period of time, that kind of thing. That stuff can be severed out, redacted, and the rest of the information is ordinarily disclosed under the provisions.
We have a question regarding notice. If individuals submit an email or letter complaint to an institution and an access request captures that as responsive to the request, is there a requirement that the institution consult with the writer of the complaint?
I would say generally yes. Complainant's information is often provided in confidence, and again, it depends on the context and the nature of the complaint. But ordinarily, it is confidential information, and so notification would be a requirement if there's a consideration that it should be disclosed.
What if the institution did not consult with the individuals or provide them notice, but removed identifying information from the letter, so address, signature, that type of thing? Would they be able to release the contents of the letter in response to an access request without consulting?
Good.
Well, whether or not a record is exempt as an invasion of privacy depends on whether the information is personal information. And personal information is information about an individual who can be identified. So if the record can be severed in a way where the individual can't be identified, then I guess that would not be personal information, and it wouldn't be an invasion of privacy to release it. I do caution, though, that there are many times when just taking out a name or taking out some other information doesn't make the person anonymous or lead to a lack of identifiability, because there may be all sorts of other circumstances that are known to the requester and to other people that identify someone in a record, even if the name is taken out.
Yeah, presumably if the letter says, I want to complain about my neighbor's fence, it's pretty clear who the letter writer is, and in that case, we would consider that personally identifiable information.
Exactly.
Right. Frank, I wonder if I can ask you to speak to this one. There are times when we're dealing with personal information, we apply what's called the absurd
result principle.
Could you discuss what kind of factors would go into that?
Sure. This comes up most often when somebody is asking for their own personal information. So they may be asking for information, let's say from a police force, for an incident that occurred that involved them and other individuals. Well, an institution might take the position that they can get some of the information, but that other information about other identifiable individuals should not be disclosed because of the privacy provisions. This office has reviewed some of those decisions, and in the past has found that in some circumstances it would be absurd to withhold information, even though it's clearly the personal information of somebody else. And the factors to consider are whether the person who's asking obviously knows the information, if it's the date of birth of their own children, that sort of thing, or whether the information was supplied by them in the first place, so that it might very well contain other people's personal information, but it would be absurd in those circumstances to disclose it. Just a further caution, this is a discretionary decision that's made by an adjudicator, and there may be considerations where it would not be absurd to withhold it, even though some of those things apply. So I encourage you to look at some of the orders on that.
And this occurs quite often with police occurrence reports, I think, right? Where there may be information in that report that has been provided by the requester, and we apply the absurd result principle.
Yes.
Right. We have a question, again, this goes back to the Friv and Vex issue. The question is, what is considered bad faith? But the specific example given is if the requester has said that they're looking for the information for the purpose of suing the institution. Sherry, would we consider that to be bad faith?
I don't think so, not on its own, no. As I've said before, you have a right to request records that relate to government business. The fact that you may want the record in order to start a lawsuit isn't bad faith, because you need access to it. You're looking for access to it. You're not making the request to harass or for a purpose that's completely unrelated to the right to get access to the record. So by itself, no. There might be other facts that would support finding that request is frivolous and vexatious, but that fact alone, no, I don't think so.
It may be an uncomfortable result, but not frivolous and vexatious. Very good question here, and one that I'm sure folks deal with frequently. And it's very simple. Which acts supersede FIPPA? And how would you go about finding out whether there is an act that supersedes FIPPA. And I know you can look in FIPPA itself, or there may be provisions in other acts that specifically override FIPPA and MFIPPA?
Yes, the FIPPA, the Access to Information Acts, both identify confidentiality criteria that can be found in other pieces of legislation which specifically override it. And furthermore, if the other legislation specifically states that it overrides FIPPA, that would also override the provisions of FIPPA. Usually those are fairly narrow. It's usually not a broad general override, but there may be, for instance, specific types of records that are held by an institution that are excluded from FIPPA. But other records, such as information about financing and things like that, might very well be accessible.
One example may be provisions found in the Municipal Act around auditors, ombudsman, integrity commissioners, and typically, the Municipal Act does speak to the confidentiality of material that those officers gather and use in the course of their investigations, and that confidentiality provision specifically overrides access to information legislation.
So if it's not in FIPPA or MFIPPA, people should look for wording in an act that says something like, notwithstanding FIPPA and MFIPPA, this material is considered confidential.
Yeah, exactly.
Right. This is a question that is potentially multifaceted, and we could spend a whole webinar on it, and maybe we should. If you have a situation where you have a complainant who has filed a complaint regarding a third party, is that complainant entitled to access to the information regarding the discipline that may have been imposed on that third party by an institution? And maybe I can start on this one by saying that we do deal with this issue under the health privacy law, PHIPPA, and the typical scenario under PHIPPA would be, we call them snooping cases, where a hospital staff person, for example, may have gone into health records of other individuals without authorization. Our position generally is that the people whose records have been accessed do have a right to know who accessed their records and what discipline was given out. We can consider that part of addressing the privacy breach that occurred. Can you think of any other situations where this type of question, where an individual has filed a complaint and wants to know the result of the adjudication of that complaint?
Well, I guess one part of the acts that may have some relevance to this question are the employment-related exclusions.
Right.
And if the discipline and if the disciplinary record are part of employment records, personnel records, then there may or may not be a right to access. It really depends on whether that exclusion applies. So the fact that employment-related records are excluded from the Act doesn't mean that the institution can't disclose them. It would be up to the institution in that situation to decide whether or not there's a good reason to disclose that information outside of FIPPA and MFIPPA.
So if it's an employment-related situation, there's a lot of discretion given to the institution to determine what approach to take to the request.
Right, subject to what other contractual or other obligations it may have.
Right. We mentioned police reports. Frank, we deal with a lot of appeals, people who have put an FOI request in for a police report and appeal the decision. Usually it's severances from it. Could you talk about what types of information we would expect to see released, and what kind of information that might be in a police report that we would generally think should not be disclosed?
Okay. Usually these police occurrence report, we're talking here about a situation where somebody's asking for a police occurrence report that relates to themselves as well as other individuals. And generally the institution will disclose information relating to the person themselves, including, what happened to them, their address and other personal information about them. But the severance will be to the other individuals involved and mentioned by name in the police occurrence report or otherwise identifiable. And that information would obviously relate to their any health information relating to them would clearly fit within one of the presumptions. The information itself in a police occurrence report is presumed to be an unjustified invasion of privacy. So there's that is always a factor. Information about their date of birth, possible previous convictions, that kind of thing would clearly fit within a presumption, would be unlikely to be disclosed. To the extent information may be disclosed, it usually has to do with a balancing between the person's own information and the other party's information.
And I'll just add as well that sometimes we've dealt with appeals where people are looking for police reports because they have a family member that died in tragic circumstances that resulted in police involvement. And there is a provision under the Act that allows for disclosure for compassionate reasons to the family members of deceased individuals. So that is an area where there might be more scope there is more scope for disclosing personal information, even despite the potential invasion of privacy.
That's a really good point. I know we have a number of orders that set out the kinds of thinking that discussion we would have in terms of disclosure for compassionate purposes. We have time for one more question, and this is a good one. It's one that we are asked about fairly frequently, and it has to do with contentious FOIs and what we sometimes refer to as the contentious issues management process. If there is a government directive or a ministerial directive that requires an agency to notify the Ministry of contentious FOIs, how much information can be shared by the agency with the ministry? And I know that we have dealt with this issue in the past. We generally take the position that a contentious issue management process is okay, as long as it doesn't slow down the FOI process or influence the result of the decision-making process. But how much information could the agency share with the ministry? I'm assuming they could share the fact that there was an FOI request and the nature of it. What about the identity of the requester?
Well, that's a good question, but as you say, Brian, it really goes to the question of whether or not there may be any, hint of political interference if the name is disclosed. So as a best practice, I think it's better to keep that out of it. What we have looked at in contentious issues management is the fact that these are really heads up. And so what is going up the chain is information that says, you should know that within a couple of days we're going to be releasing this kind of information. It may result in a question in the House or a question from the media. Those sorts of heads up, as long as they don't slow down the process or taint the decision-making, influence the decision-making, those are perfectly valid.
Yeah, and I think you raised a good point. It's always important in this process to keep in mind you want to avoid the suggestion about political influence on the response that's going out. Great. That's all the time we have. On behalf of Sherry, Frank, and everyone at the IPC, I want to thank you for watching today, and a particular thank you for all of those who have sent in questions to us. Please keep a lookout for future installments of our webinar series, and feel free to send in suggestions about issues you might want us to deal with. So again, thank you and goodbye.